Hello, so I'm carrying on with public body liability. So I looked at some of the things that had to be considered, and the courts, they don't want to be unduly cautious because it might cause public bodies to be excessively defensive and not do things that are useful to the public. There are other remedies which can be granted, sometimes a judicial review, sometimes a claim can be lodged pursuant to the Human Rights Act, sometimes people can complain to an ombudsman. And so this might provide justice without a tort claim having to be lodged. So there are statutes which are pertinent to this, and many of the functions come from statutes. So a statute can be saying that a council shall do something. It can give a power to a local council, so they can do something if they wish to. They're not obliged to. But most of the duties there are very broad, as in to provide education. Well, I mean, like to who and how and all the rest of it. So in these duties and powers, the public authority has a lot of latitude in what they're going to do. Otherwise, local government wouldn't really be government. It would just be carrying out orders from above and not making decisions for itself. There's a different tort that's not negligence called breach of statutory duty, but that is very seldom pertinent to the liability of public bodies. The issue is this, how far the common law tort of negligence can come from statutory duties or functions and powers. Now, the answer is usually that any such duty, such a duty may, but doesn't always come, so long as it's not inconsistent with and doesn't go against the statutory regime. So let me give you a few examples of how this works. So there are some tentative rules, and the issues are ones that we're going to have to look at and do in some depth. It's quite challenging. So there's a recent authority about this, about a statutory function will rarely bring the kind of proximity between the citizen and public authority that would be enough for the second limb of the Caparo test, the proximity. Lord Justice Sedley in Home Office against Mohammed 2011 said striking out a negligence claim by a Kurdish chap whose applications for indefinite leave to remain in the UK have been successful only after very lengthy delays because of some terrible maladministration identified in judicial review proceedings. But despite all that, the situations of duty of care exists, and there's liability for damage caused by way a duty or power and how it was executed. These can be between a public body and the claimant. There's a pre-existing duty of care, so that improperly exercising a power or failure to exercise a power could be a breach of duty. So the duty of an employer to keep an employee safe from stress, for example, in Connor against Surrey Council 2010. There's a common law duty and a statutory power. These two are consonant with each other. The public law authority can execute its duty or exercise its powers to create a permanent organisation, and then it has a duty of care to those who use the organisation, for instance, the ambulance service and educational psychologists. The public authority can be seen to have assumed responsibility to a person, Barrett against Enfield London Borough Council 2001, or Swinian Chief Constable of Northumbria Police 1997. Okay. So statutory function is supposed to benefit one group of people. There's great reluctance to accept a duty of care to other groups who may be impacted by the erroneous decision. For example, the parents can wrongly be suspected of abuse. JD against East Berkshire Community NHS Trust 2005. Or the owners of a care home were wrongly suspected of mistreating the residents. Jane against Trent Strategic Health Authority 2009. So the public authorities are going to be reasonably vigilant. But at the same time, inevitably, they're going to accidentally, wrongfully accuse people sometimes. So it's difficult. And if they didn't intervene when they thought there was abuse, they'd be in trouble. And if they intervened when there was actually no abuse, but they were mistaken, they might get in trouble that way either. So there are problems about imposing liability if the authority is said to have caused damage by failing to exercise its power, as opposed to using them, but using them badly. So the Human Rights Act 1998 is very pertinent here. So the European Convention on Human Rights has got Article 2, the right to life, and also Article 3, which forfends torture, inhuman and degrading treatment. Article 8, which is respect for private and family life. Now, these introduce obligations for public authorities. And there's some positive obligations, not in the sense that they're good supposedly all of it's good, but mean they have to do something as opposed to refrain from doing something. Article 2, it's not enough to simply prevent public authorities from killing people, but the state has also got to try and prevent you being killed by somebody else. There are violations of convention rights, and these are torts, but they are not. And where they're not, the domestic courts can respond in two different ways. They could expand the law of tort to create a remedy for a violation of a convention right, or they could leave the common law untouched and allow the victim to seek action for breach of the convention right pursuant to Section 7 and 8 of the Human Rights Act 1998. Now, this action is different from a common law action in three different regards. One, it has to be brought within a year, although this can be extended under Section 7.5b, and damages are up at the discretion of the court, Section 8.3. And the third way is the measure of damages is going to be less than under the common law rules. So the court was initially loath to find a duty of care to avoid conflict between the requirements of the ECHR, and there's some social worker cases about this. The last few years they refused to do so, and they allowed the claimant to pursue a remedy under the 1998 Act. For example, Jane against Trent Strategic Health Authority, the House of Lords refused to recognise a common law duty on the Public Health Authority because then it would really mess up the way that the duty of care is exercised when public authority is not involved. There's Commissioner of the Police of the Metropolis against DSD and another, 2018, as in that the Metropolitan Police, as in the London Police. This is about supposed violation of the respondent's rights under Section 3 of the ECHR. There was Mr. Warboys, who was a cab driver in London, and he committed a number of rapes, and he carried out these sexual offences whilst he was a licensed taxi driver. DSD, one of his victims, she was subjected to a crime in 2003, and she said that because they hadn't properly investigated her complaints, this was inhuman and degrading treatment against Article 3. The police reviewed the sexual assault cases in February 2008 because there was a media appeal. Warboys was found guilty of 19 counts, including an assault on someone known as NBV, because she wanted anonymity. Both women, they brought action against the police, and they said that the police had not carried out proper investigations into Warboys' crimes, and therefore this was a breach of their Article 3 rights. The Supreme Court found that Article 5 imposed a positive duty on the police to investigate crimes or allegations of inhuman and degrading treatment by natural persons, and they had to do so expeditiously and effectively. Obviously not guaranteeing they would actually catch the person and not guaranteeing that would lead to a successful prosecution. The court underscored that the errors had to be grave ones to give rise to a breach of duty. They couldn't be trifling errors or just one error. And the situation the police held to be liable for failing to investigate a crime that are rather strict and narrow. So the result of this decision was created an extra burden on the police, who's already stretched very thin. There was Smith against Ministry of Defence 2013. The UK Supreme Court said this is an example of the combat immunity in negligence of the Ministry of Defence to members of the military. The Supreme Court, they reduced the scope of combat immunity in a claim that was brought by the families of soldiers who were killed in a friendly fire incident in Iraq that wasn't actually on a battlefield. The claimant said the Ministry of Defence was in breach of its duty of care because it didn't provide proper equipment and technology to mitigate the risk of friendly fire, and they didn't provide proper vehicle recognition training before deployment to the combat zone. So the Supreme Court said that the decisions about training and procurement and so on, that's for the MOD, and conducting operations at high level are connected to the political decision about what they're going to do, and there are obligations, positive obligations under Article 2 of the ECHR, and they need to be given effect. So the notion of combat immunity, it has a rather restricted scope. It's to do with acts of war or imminent armed conflict, not failures in other stages of some military campaign. Because the Ministry of Defence had this immunity because on a battlefield, no, you can't keep people safe. The whole thing is dangerous, and you are firing at other people, and mistakes are going to be made, and we can't pretend that it's as safe as an ordinary situation. Friendly fire is when your own side accidentally kill you because they mistakenly think you're the other side. All right, that's enough. Bye-bye.